Good afternoon, and thanks for joining us here on Law and Crime. I'm Anjanette Levy, and I will be here with you for the next hour, taking your questions on the YNW Melly double murder trial mistrial. Judge Murphy declared a mistrial on Saturday afternoon after jurors told the court for a second time they could not reach a unanimous verdict. This came after 14 hours of deliberations in Broward County, Florida. The jury, of course, was sequestered. Now the state has 90 days to retry Melly, but the defense can also waive that 90-day time period. We should find out more about that on Friday. The prosecution says Melly, whose legal name is Jamell Demons, shot and killed his two best friends in October of 2018. The defense claims Melly is innocent and was at home when Chris Thomas and Anthony Williams were murdered. The defense says Cortlen Henry, Melly's co-conspirator, was involved in the murders. They said that in their closing arguments. The Murder on My Mind rapper, Melly, faced the possibility of the death penalty if convicted. And we know you have a lot of questions about all of this. They're already coming in, so let's jump right into them. But I want to reach out to Terry Austin first to tell us a little bit about what the mood was like there. Linda Kenny-Bodden is with us as well, as is Offie Patterson, an expert in hip-hop and legal matters. So, Terry, first of all, before we get to the questions, tell us what it was like in the courtroom when that mistrial decision was read by the judge.
Well, Anjanette, it was on a Saturday, so the courthouse in general was very quiet. You could hear a pin drop everywhere. No one was there except the security folks who were in the courtroom. And the room wasn't filled either because the judge gave us 30 minutes to get back once he knew the jury had a question or whether or not the jury had a decision. You buzz once if there is a question and twice if there is a decision. And so they buzzed once, and the question was, or the statement from the jury was, we still are not able to come to a unanimous decision. And that's when the judge read the mistrial to them and said, look, based on this, I am going to declare this a mistrial. There weren't that many people in the courtroom because everyone had not gotten back. The defense attorneys were all there, the prosecution was all there, but the members of the families were not. So it was quiet and empty. But, you know, I looked at the faces of the attorneys and I looked at YNW Melly's face. I think everyone was pretty stoic. They just listened and, you know, no smiles or no frowns, just basically taking in that decision, and that was it. And after that, the attorneys talked about, as you said, Anjanette, that 90-day period and setting up a status conference for July 28th, which is next Friday.
Yeah, and we'll have that covered for you on Friday. We hope to be streaming that live to you. So let's get straight to the questions because there are a lot of them. Melly, of course, remains in the Broward County Jail. He was not released. A lot of people, I think, had misunderstandings about whether or not that would happen. So let's go ahead and get to the questions. Linda, at Jeffy NY, Jeff YNW4, sorry, from Twitter asks, can the state try Bortlen and Melly at the same time? Will it be the same judge and prosecutor?
Well, they really can't try them at the same time because of the statements that were given by Cortlen Henry. Remember, he actually was interviewed by the police and he gave statements. So they're not going to try them at the same time. And if they did, they'd probably use separate juries. Will it be the same judge? Likely will be the same judge, assuming that it gets tried within the next year with the retrial. The same attorneys? I don't know about that. Will the prosecutor assign a new prosecutor? Will the defense, if they were privately hired, be hired? Can Melly afford hiring the same team and all? So we'll see about that. My gut feeling is that you will have the same defense team, but you may have a different prosecutor taking a new look at it. But we'll have to see.
Yeah, we will have to see. And it appeared during that one hearing for the pretrial hearing for Cortlen Henry that Christine Bradley was going to be prosecuting it. She at least was appearing there for that. Our next question comes from 797.blkcat or Black Cat from Instagram. How many times, Offie, can a case go through a mistrial?
All right, thank you, 797. I actually did some research this weekend on that because I was wondering how many times can a person be re-prosecuted? And I found out that there's no official record keeper on how many times a defendant has been re-prosecuted in the United States. I did find a case, I forget his name, I think it was Marcus Roberson out of Mississippi. This is just one case. He was retried at least 6 times, and at least 6 trials went to verdict. I think the trial actually started a total of 8 or 9 times. So it really depends on the prosecution and the evidence that the prosecution believes that they have. It also depends on the public, the outcry of the public. There are a lot of factors that go into it, but usually a prosecutor can just keep bringing it back. And it's really hard on the defense because you have to pay for that defense every time. But it's also, a balance with the prosecution because you're going to lose witnesses if you keep trying to re-prosecute a case.
Yeah, I mean, we would hear from many of the same witnesses, I would assume. I don't know. I have a lot of questions
if you can resubpoena
about
them.
this, so hopefully we can get some of them answered. Some of these may not want to testify again, and Travion Glass in particular was reluctant to begin with. Wayne Miller from Facebook asks, are you going to live stream his court date Friday? I will answer that part of the question because Wayne has a lot of questions, Terry. Yes, I assume we will. Will there be a possibility of bond, Terry Austin, and what time is the court appearance on Friday? It's at 9 a.m., but Terry, do you think there is a possibility that Melly is given a bond?
Well, I asked that question of the defense attorneys. I thought that they might try to do it that day once the mistrial was declared, and they wouldn't answer that question. They're leaving that open. I think they should try. It's not guaranteed they'll get it. I mean, I think the same considerations that the judge considered initially, he will consider now. This is a death penalty case. It's extremely rare, if not ever, someone for a death penalty case would be let out on bond. So they may think, the defense attorneys may think it's not even worth asking the question. But I'm assuming that they're going to put everything forth that they can. They renewed all their motions. They protected their record. And I'm assuming that they'll probably ask for that. It's a mistrial, meaning you start all over, so why not? But I doubt very seriously if he's going to get out on bond.
Linda, this next one's for you. It's from _.toofunnyYX from Instagram. Could this mean that Melly gets retried after his co-defendant? Would that be good or bad for Melly? We already know that Cortlen Henry's trial is scheduled for October.
Right. If I'm the prosecution, of course, if you're the prosecution, you want to go after Melly again, unless you're trying to make a deal with Cortlen Henry. All right. So that could be a very interesting thing, because what if the prosecution makes a deal, turns state's evidence, he comes in? Does that help the prosecution? Or does the defense say, as I said earlier today, hey, wait a second, you targeted him from the beginning, you targeted Melly from the beginning, he never looked at anybody else, and now you're giving deals away like they're candy, like Oprah Winfrey here, you get a car, everybody here gets a car. And the only one who doesn't is Melly, because you want to convict the person with the name, even though you don't have the evidence. So will he be tried beforehand after Cortlen Henry? I think the prosecution is going to try to make a deal with Henry.
I think so too. We'll see if that happens, but that seems like a key witness for them. Let's get to our next question. This is from Des from YouTube. Offie, what happens if the state retries Melly and there's another possible hung jury?
Great question. We just talked about this. I believe that the state is going to retry him again. I think that, again, I looked up a case where a gentleman had been tried multiple times, actually, on a double murder trial similar to Melly's. It was in Mississippi. And I believe there was also gang affiliation. So there was a lot of similarities. But I believe the state is going to try until they can get their man. The problem, again, that the state is going to face is the witnesses. Are they going to still have those witnesses around? Are they going to still have the same leverage on those witnesses that they did this time around? Are they going to be cooperative? How are they going to present on the stand? Are they going to be able to find any additional evidence? The problem for Melly's side is he going to have the finances to continue with such a robust defense team?
And that's the big question. He's been incarcerated behind bars since early 2019. So any money he's been making has been off his old music, I would assume, and whatever other kind of deals he had in the works. And we could see from the trial, it looked like all the money goes to his manager 100K Track, Jamison Francois, like he handles the money and then he disperses it to Melly. So we don't really have enough information to know how much money Melly has and how much he can pay for a second trial. Jacqueline from YouTube asks, why did the judge allow the jury to be deadlocked instead of requesting them to review longer? So Terry, you know, the judge had already pushed them once to, you know, he read the Allen charge on Friday to them, sending them back in.
Well, that's exactly right. He's only going to give that one charge saying, look, you just need to go back and work with each other. I'm not saying you have to change your votes, but you do need to try to go back and work it out. And if you can't, there will be a mistrial. And that was the charge. That's the Allen charge. It's pretty standard language there. They did do that once. They went back, and it wasn't long afterwards that they came out and said, look, we are still deadlocked. In my opinion, for a death penalty case like this, they really could have gone at it a bit longer. But the judge was very respectful of that jury in terms of what they were asking and what they were requesting, and so he took their word for it that they could not come to a decision, and he quickly called a mistrial. So he did what he could. It didn't work, and the law states at that point it's a mistrial.
Sensational_sweets. We kind of already touched on this, but I think it's a good question, Linda, from Instagram. Can Melly get house arrest at the Friday hearing? I think this is a good question only because we've talked about, could he get a bond? If you're on house arrest, you get an ankle bracelet. You're not allowed to leave the house, or if you are, it's only during certain hours.
Could he? Well, it's within the judge's discretion. Will he on a double homicide death penalty case? Absolutely never. That's really what it comes down to.
All right. We're going to take a quick break, but keep those questions coming to us on YouTube, Facebook, Instagram, TikTok, Threads, and all of our other social media platforms, and we'll get to as many of them as we can. Stay with us. I'm Anjanette Levy, and you are watching Law and Crime. Welcome back to Law and Crime. We are taking your questions here during our lunchtime show on the YNW Melly double murder trial mistrial. If you didn't follow it over the weekend, we're here to tell you that the judge declared a mistrial after the jury reported to the court that they could not reach a verdict after about 16 hours of deliberation. It was a little bit more than that. So keep your questions coming to us on YouTube, Twitter, Facebook, Instagram, Threads, and TikTok, and we'll get to as many of them as we can for the rest of the hour. Our next question is for you, Offie. Dana Treasure from YouTube asked, do you think that the witness will retestify? And I don't know if she means just one witness or witnesses plural, like all of the witnesses we saw in the first trial.
Thanks, Dana. I think that's a great question. I think definitely for the prosecution, the witnesses will retestify. It's part of their job, especially the experts. They'll be there to retestify. The problem for the prosecution is going to be your witnesses like Travion Glass, Melly's girlfriend's mother, other lay people. That's going to be the issue, even for the defense, whether your strong alibi witness is going to testify. So that's always an issue when you retry a case, especially in this particular case. We know the prosecutor said, a particular witness hated her, but she's just doing her job. She needs to get those witnesses on the stand. We know nobody ever wants to have to testify in a case as a lay person because a lot of times these issues involve people in your community and you have to go back to your community and be accepted. So it's a lot. But, I know the prosecution hopes they can get their lay witnesses back. Defense hopes he can get his alibi witness back, which I thought was really solid.
This next one is for you, Terry. It's a pretty long one, so I'm going to try to condense it, but it's from B_Reelin802. My question is, why didn't the prosecution or the defense mention anything about Melly's mental health? He's openly admitted to having split personalities. He calls himself Melvin because he's got that other character.
Well, I think there's a difference between saying something on social media or claiming that you might have some sort of mental illness or disease, and there's a difference between actually having that diagnosed and admitting that into evidence. So we didn't have any of that here. There were no doctors who diagnosed him definitively with anything, and none of that was asked to be introduced into evidence. Now, they may have had some pretrial motions where both sides were arguing one way or the other, and the judge said, no, none of it's coming in. But the reason you didn't see that at the trial is because there was no evidence to that effect. And him saying it on social media doesn't mean that it's absolutely the case. He may just be saying that because he wants people to think a certain way. But unless he has a physical diagnosis and unless those attorneys wanted that introduced, it's not going to be seen in the trial.
Well, and the whole defense here was he didn't do it. They can't prove it, and he didn't do it. So that's part of it too. And when I interviewed his manager, Track, he said that whole thing, Melly Melvin's an act. It's part of his shtick. It's part of the show of the music and everything. So this one's a good one for you, Linda. Aziz NX Tup _11 from Instagram. Is this mistrial more of an advantage for the prosecution or for the defense?
Okay, so this is a point that's argued all the time. And we see a lot of times where there has been, as Offie said, trial after trial after trial, and the prosecution has no limit. There's a case that went to the U.S. Supreme Court on that, whether it was a violation of substantive due process for a defendant. No limit. They tried 12, 13 times. So with that said, sometimes a prosecution will tighten up their case, but other times I have found that a defense will also tighten up their case and know what, and have interviewed jurors and know where the seams are in the prosecution case. So my view as a defense attorney, I would rather have a hung jury and a retrial as opposed to the prosecutor. If I'm a prosecutor, I just don't want to go through that again. I remember being a prosecutor saying, I don't want to have to try this case again, because then you can be cross-examined on all the transcripts, the police and all, and I think that is a disadvantage.
I remember covering a case, it was a totally different type of case though, where there were 2 mistrials, and then the prosecutor said basically, we've interviewed jurors in 2 mistrials who've said you will never ever get a different verdict or a different result in this case. So he just dropped the 3rd trial. They didn't go forward with the 3rd case. So It all depends on the facts of the case and different dynamics. TikTok question for you coming right at you, Offie. Do you think that it was Bortlen and that Melly just happened to be with him? And this is from @5star BIII.
Hey, 5-star. I don't have a theory of the case. I'm just listening to the evidence that was presented, and I think the prosecution does not believe that Bortlen was the triggerman. They believe that Melly was the triggerman, or at least the person who was seated in the rear driver's side seat. Something that I thought was fascinating to me was I think it was the crime scene expert. He said that there definitely was a body in the rear driver's seat when Anthony Williams and Juvy were shot. And we saw the picture. There was absolutely no blood splatter and no, I guess, any type of fluids in the seat. So we know that there was a body there. So according to the evidence, Bortlen was not the shooter because he was in the driver's seat. Whether he got in the back seat or somehow maneuvered that, I couldn't tell you. I don't have an opinion on that.
Yeah, it was very interesting when we saw the back seat that it basically looked clean on that passenger seat behind the driver's side.
And Jeanette, can I just say something on that? Which is why the defense always has to go see the car. They didn't see the car. You don't know unless you go with your expert that maybe something was missed there. And I think one of the bad things that the defense did do, even though they did a great job, is not going to look at this car, not bringing an expert with them to look at this car, and seeing if there was an alternate theory of the shots that occurred that would suggest that even though it may have been somebody in the back seat, maybe the jury, the other persons who were for not guilty or for guilty would have turned if the prosecution's theory of the shooting could also be proved wrong.
I thought that was interesting too, that they had not visited the vehicle. I mean, that seems like one of the first things you might do is visit not only the scene of where the state claims it happened at US 27 in Pembroke, but also look at what they claim is the crime scene, the interior of the vehicle. So I thought that was really shocking. JMan3434 from Instagram. This is a question coming to you, Terry. If this has to get retried, will it be the same judge and attorneys? Did you get a feeling on that when you were in court on Saturday?
Well, my impression, it will definitely be the same judge, but, you know, that could change too. I think we dealt with this question earlier, and I agree 100% with Linda. We don't know if it's going to be a different prosecutor, and we don't know if it's going to be the same defense team. That defense team had 4 different people from 4 different areas. They had a death penalty attorney, and obviously we had Stuart Edelson, and we had David Howard, and we had Raven Liberty. They were the attorneys who were taking turns in terms of the opening and the closing, and it all depends on what YNW Melly wants and needs. If he can afford that same team, I'm certain he'll bring them on. They've been there, they've tried it, they have that expertise. If he thinks he wants someone who has more expertise and he has the money, he'll bring them as well. As far as the prosecution, I think that Ms. Bradley might try it again. I know she is, and we talked about this before, involved with Henry's case. She knows more than anyone else, and I think she's learned from the case what she can do less. We had that first witness who had all of that information about guns, and we got quote-unquote certificates on guns. She knows now that was too much, and that jury doesn't want to hear all that. Maybe the next time around she'll do less, or they could bring someone who has more experience. We don't know. We should know more on Friday, and we're covering that. So we'll see what happens at that point.
Our next question, well, actually, before we get to a next question, Linda, I want to ask you this. This is something that's been weighing on my mind, or I've been thinking about since we've been talking about money. How much do you think it costs to defend a case such as this one?
Well,
are we talking hundreds of thousands of dollars?
Yes, at least, especially since the defense may have had experts that help them, obviously. They also hired a mitigation specialist. That's the person who starts and goes out. And quite frankly, when you have a death penalty case, you look at that first. You look at everything in Melly's background. That costs a lot of money because you have to get records on his birth. You have to get records on his upbringing. You have to interview anybody. That's a very expensive process that people don't consider. And that is aside from the attorneys. That's just doing all the backup work with the investigators on that. And depending on what the attorney's fees are. Now, it didn't look like they had a lot of experts unless they hired experts to advise them and decided they didn't need experts on the stand. That could also happen. So yes, could a case like this cost anywhere from $500,000 to $3 million for a defense team? Absolutely.
Wow. At Chambers Isms from Twitter, does the state intend to bring the case to trial again, Afi? We believe so. What should the state do differently next time? We could probably go around the squares on this one. So what should the state do differently next time, assuming there's a second trial?
Okay, well, first, I would bet $5. Now, I know that they're going to try this man again, and they're going to try him again, even if they get hungry after hungry. I think for me, I think the state needs to narrow their theory. I think they were all over the place, especially, it started with the gang theory. I think the expert that they got, he had never actually been in a gang. He had only taken courses. And some of the things that he was interpreting, I think for the audience members, me as an audience member, and even possibly the jurors, they were probably saying a lot of the stuff that you're interpreting as gang related is slang that I use with friends and family, or that my kids, nieces and nephews, or even grandkids use. So I think the credibility of your gang expert and your theory with respect to the Melly's gang membership or apprenticeship or affiliation, they also need to narrow down what they want to do with all of the text messages. Narrow down their whole theory of that night, narrow down the timeline, just narrow, I guess is what they need to do. And just give the jury something simple and basic to focus on. Because if you saw by the questions the jury was asking, they were trying to re-put everything back together themselves. That's what I got from the questions that they were asking when we were reading back testimony and getting more evidence read back to us.
Mm-hmm. Yeah, the gang expert, that seemed to take a really long time, and then the whole thing about the mask and all of that stuff. So I wonder if they might forego that the next time. What do you think could be done differently next time, Terry?
Well, I definitely think she should shorten her case, and by she I mean the prosecutor. I think Bradley had a lot of information, and when you look at the jury, even though they were paying very close attention, you could tell their eyes were getting glazed over. There were several witnesses. I would just hone right in, as Afi said, on what are the key points from this witness. I wouldn't give the court a lesson on guns. I wouldn't give them a lesson on DNA. I wouldn't give them a lesson on trajectory. Just get in and get out. And I certainly wouldn't show all of those text messages, the Facebook, social media messages. What is it you're trying to do? The other thing that I would absolutely positively do, whether I was the defense or the prosecution, I would have a demonstrative which shows a timeline. Pick the key points you want. Where was the car? Where was the phone? Where was the email? Put that all on one timeline so the jury can understand, okay, this is where 9807 was, Melly's phone. This is where the car was at that point in time. These are the text messages that are occurring simultaneously. The thing she did in her closing, and I'm talking about Bradley, she did a great job pulling together the pieces, but I would have taken it a step further and make it simple for that jury. Spoon feed them. They should not have any questions at that point. She should basically just give them the entire story on one piece of demonstrative evidence. I think that would have made a big difference. And I'd do the same thing if I were the defense team as well.
Linda, your thoughts?
Okay, two things. First, the only thing you have as a trial lawyer before a jury is your credibility. So you do not open as a prosecutor and suggest that there was a confession by saying there was a text that said, I did that, that was a confession, because when that text came out, it didn't make any sense. It wasn't in response to the question, and the defense had a field day with it because all the other texts showed that in terms of how Melly speaks. The other thing is, you mentioned, of course, to the jury that there's another text message, if you're going to go there, to Travion Glass that says, I didn't do that, okay, because it would have created a war. And if your theory is that the motive was gangs, and he's saying he didn't do that because of gangs, it just undermined the whole prosecution. So if you're going to have a motive, you better pick one, but you don't say somebody confessed when you cannot prove that.
All right, we are going to take a quick break. Keep the questions coming. You are watching Law and Crime. We'll be right back. Welcome back. I'm Anjanette Levy, and you are watching Law and Crime. We are taking your questions this hour in the YNW Melly double murder trial mistrial. A judge declared a mistrial on Saturday after the jury deliberated for 16 hours and couldn't reach a verdict. So this jury was split somehow on this verdict between not guilty and guilty. We are taking your questions, so keep them coming in on YouTube, Twitter, Facebook, Instagram, Threads, and TikTok. We'll get to as many of them as we can. With me is Linda Kenny-Bodden, a defense attorney and host here at Law and Crime. Also, Law and Crime's Terry Austin, fresh back from Broward County, Florida, where she was covering the trial, and Offie Patterson, a legal expert in California. So this one will go to you, Terry, since you were in the courtroom on Saturday. At Charmin_S from Twitter asks, why was Melly smiling and stuff when court ended?
Well, I was watching him very closely because we knew the judge was about to declare this mistrial, and he did have a small smile on his face, but it wasn't a big grin. I thought he was just basically, okay, well, this is where we are. You know, he's talking to one of his attorneys there. You see him talking to Raven Liberty, and he's acknowledging the fact that the jury could not come to a unanimous decision, but I didn't think that he overreacted. If you recall, in the very beginning weeks of the trial, he was far more demonstrative. But as the trial went on, that changed and he became a little bit more subdued. You'd see small smiles, but you wouldn't see anything really grandiose. And part of all of that is this is the only time he is out of that cell. He is in there 24/7 unless he's going to trial. And I think it gives him an opportunity to express himself. We saw him praying. Those kisses were really kisses to God. We found out from some of the family members that it wasn't that he was just being playful. He was praying and he was blowing that up to heaven. So I think he had a smile, but I don't think it was a big smile. I think he just acknowledged, okay, well, I guess we're going to be at this another time.
Linda, this one's coming to you from TikTok at user 593-778-3511-391. Not sure what that means, other than it might be like the 5 billionth or zillionth user. What happens if Melly cannot afford a legal team? This is a good question because I was thinking that myself. What if he seriously on paper doesn't have any money despite being a rapper?
Well, I'm going to call you 5 just to shorten it, okay? You're on my jury list. He will be appointed counsel, just like we saw in many cases in Broward County where there are public defenders. He will be appointed a public defender. He'll be appointed somebody who has done death penalty cases. He'll have a same type of team, or they will apply, which you can do. You can apply in Florida if you're a private attorney to take a lesser rate. It's very, very cheap. I mean, it's a lot lesser, okay, if these are your private attorneys. And this, to save the county money, and the court does have the ability to say, yes, okay, you can do that for whatever it is, $50 an hour, $5 an hour, whatever it is. I'm not sure what it is, but it's lower. So one of those two options would be on the table.
I have a follow-up to that. How negotiable are attorneys' rates? Because we know that there are attorneys who will take a case pro bono, or they'll just look at it and say, okay, I'll defend this case for X number of dollars. How negotiable is that?
Well, the state rates are not negotiable if you're going to be appointed as substitute counsel for a public defender. They are what they are. It depends, Anjanette. You know, if I'm really interested in the forensics of a case, I may take it for a lesser rate than my normal rate because I'm interested in there not being, and I won't use the lynching word, but that I don't want the justice system to be utilized as a way to convict somebody who I think may be not guilty. So there are all different reasons attorneys can take cases and take them at a lesser rate, or take certainly you could take a lesser rate, for instance, before trial as opposed to in trial, or you could set your trial rate and cap it, not be hourly. So there's many different ways that attorneys deal with cases. Either they want, or that a client will come to them and only has a certain amount of money, and if they think the client is not guilty, like I do sometimes, I'll take it at a lesser rate.
Now, Offie, I'm going to send this one to you because there may be people joining us who don't understand the mistrial concept or what that means. So we've had a few questions about what exactly is a mistrial. One came from Eduardo Gwilby, I believe is his name, from YouTube. So explain what mistrial means.
All right, thanks, Eduardo. So in this case, there are many reasons that you can the judge will order a mistrial. So we saw, for example, during this trial, I believe the defense counsel asked for a mistrial twice. One was for example, when the jury heard something that they shouldn't have heard, meaning perhaps the prosecution tried to introduce evidence or a prosecution witness said something that was so extremely inflammatory or prejudicial against the defendant, and you couldn't unring a bell, you couldn't walk that back, and the defense counsel says that this warrants a mistrial. So that's one example of a reason you can get a mistrial. The other is, in this case, also when you have a deadlocked jury, a jury who is just unmovable, unshakable, not going to change their decision. As we know, when a judge orders a mistrial, the prosecution has the right to retry that case. And I think, Linda, you said that there was a recent U.S. Supreme Court decision that said it's not any type of misconduct and to retry a case multiple times. I even found a case, a double murder case outside of Mississippi, where there was, similar to this case, there was some gang affiliation, and that gentleman had been on trial or retried at least 6 times. So yeah, back to your original question. When you have a mistrial, the prosecution can bring that case again against the defendant. And in this case, Melly will likely stay in jail until that trial date.
In a mistrial, they'll say it's mistried. So either we have a hung jury, or the, error or whatever happens is so egregious that the judge decides that fair trial is not possible. There are different ways this can happen. So this is from TikTok for you, Terry. At Trey Joseph 23 asks, after so many mistrials, can the judge overrule and say enough is enough?
Well, it won't be the judge who makes that determination. It will be someone who is making a motion on behalf of the defendant saying, look, this is a violation of my due process. I don't think that that will prevail, because we have seen, as Linda mentioned, Supreme Court saying, look, you can be tried over and over and it's not a violation of the due process. But I think if it ever gets to any extreme, like 12 times, at some point it is a violation. So, my view is make the motion if you can. You don't know if it'll prevail, and if you do prevail on that sort of motion, it may or may not reach the Supreme Court if there's no appeal of the response there. But it won't be the judge saying that. It'll be the defendant making a motion saying he should not be retried again and it's a violation of his constitutional rights, and then it'll be up for an appellate court to make that determination. But chances are the prosecution is going to be able to bring the trial multiple times, to retry multiple times, because they have that right.
All right, we are going to take a quick break. So keep the questions coming in on YouTube, Twitter, Facebook, Instagram, TikTok, and Threads. We'll get to more when we come back. I'm Anjanette Levy, and you're watching Law and Crime. Welcome back. I'm Anjanette Levy, and you're watching Law and Crime. We are taking your questions in the YNW Melly double murder trial mistrial. The judge declared the mistrial on Saturday, so we're going to get to as many of your questions as we can in the remaining time we have left. Linda Kenny-Bodden, I think this is a great question for you. Michael Jorgensen from YouTube, who's a frequent question asker, asks, is there any reason to believe that the defense will change their strategy given that the single witness was a little surprising to most?
That is such an interesting question, because we had debated all the way around, and then when the defense said they're just going to put on this witness, and it was a star witness, right? It was testimony we hadn't heard. No one had alluded to it. The prosecution investigator hadn't questioned him, Glass hadn't questioned him at all. And the prosecutor questioned him only like a year before trial. So I think that was stunning, but that won't have the same effect next time. So the defense is going to have to evaluate whether or not they're going to want to go with, as we talked earlier, a forensic expert to put a little bit of doubt into that reconstruction that we had there, because maybe you're not going to have the same impact with, all right, we're going to let everything slide. We're just going to say Melly got out of the car and he didn't do it, because the prosecution's going to be looking for everybody to say now that Melly didn't get out of the car. There was no reason for him. Or maybe the prosecution will say Melly did get out of the car because he knew there was going to be a shooting and he wanted his best friend's shot. So, you know, I don't know about the prosecution, but the defense is going to have to reevaluate that. I agree with you, Michael.
Godstyle from YouTube, Afi asks, detective claimed, I think they're talking about Sergeant Williams, detective claimed it wasn't a drive-by due to the bullet holes, but it's been seen multiple times that drive-by shooters come to a full stop in the car. Why wasn't that taken into consideration?
I agree. When I saw that testimony, the first thing I thought was, you know, we are so used to, we're conditioned by movies. Like, just because you hear drive-by, it doesn't mean that two vehicles are passing each other and they're bullets that are flying from a moving vehicle. Drive-bys can happen many ways. You can drive up to the car, you can drive past the car, people can get out and shoot, people can stay in the car and shoot. So I think that that wasn't challenged, and I think that it should have been. There are lots of ways that a drive-by shooting can occur. So I think that was a missed opportunity.
Terry, I'm going to combine two of our viewers' questions here because they're pretty much the same. Andre P. David and both Cami Phillips and Andre from YouTube asks, basically, won't it be hard to get jurors since this was widely publicized and live streamed? Cami's portion of it is, do you think the case will be able to get a fair jury considering the case was broadly streamed?
Excellent questions. I do think it will be hard to find a good jury panel, because if you weren't already sitting on that jury, you are someone who probably watched the live stream from Law and Crime. And so I think many people are going to have pieces of information that they shouldn't already have. And when they do that voir dire and they ask those questions, have you seen the live view of this trial when it was on? And if you answer yes to that question, you are out. So it could very well be that they aren't able to get a pool of jurors who haven't seen all of this, and they may very well have to, someone could make a motion to change the venue because of that. We don't know if that's going to happen yet, but it's a possibility. That's why I think those are two great questions by our viewers. Yes, it could be a problem getting another jury.
Linda, Jason T. from YouTube asks, how much of a factor do you think the defendant's song, Murder on My Mind, played in the minds of the police, prosecutors, and jurors?
Oh, Jason T., what a great question that is, given the fact the prosecution said she wasn't going to go with the lyrics or the music. I think it played a lot. I think the fact that he's a rapper played a lot. I think the fact that he may be in a gang played a lot. I think all that played a lot. And one of the questions I had is that, are we prosecuting him, or is the defense suggesting that he's being prosecuted because he is a rapper in a gang, and all rappers in the gang have to be guilty, and they were trying to appeal to the section of the jury or the people in the jury who may think along with the police. I think that's exactly what they thought initially, and I think Murder on My Mind certainly played into it, and we'll have to see if the prosecution decides next time to go there with the lyrics, even if it's just the name of the song, don't we?
It's pretty controversial though, Afi. I mean, going into these song lyrics if they bring these into court? This has been an issue in cases across the country. In fact, California has legislation about this that Governor Newsom signed into law, I believe, last year.
Mm-hmm. Yeah, so there's legislation that's come out recently in California, legislation that's recently come out in New York as well, with respect to introducing song lyrics into a trial. So I think in particular in this case, I did look into it, and I think the murder on my mind occurred before the murder. So it really couldn't be used in the trial from what I understand. Yeah.
Yep, he wrote that, I believe, when he was doing time in jail on another crime. At JustBrit910 from Twitter, do you think the defense will bring an expert in this time to confirm that those first shots happened from someone standing outside of the vehicle, because they're going to need to stick with that story at this point? Your thoughts on that issue, Terry?
I absolutely think they should bring a crime scene reconstructionist to give another theory. Like Linda said before, that jury needs to hang their hat on something. Obviously, the defense does not need to prove their case. And we heard Stuart Adelson say, look, I don't have to do anything. I probably wouldn't say that to the jury. They want you to do something. And in the back of their minds, they need some other evidence to contradict what the prosecution has put on. So when the trial resumes again for the retrial, I do think they should put someone who can say, look, like Afi was saying, maybe the cars were stopped. Maybe the person got out of one car and shot up, Melly's car. Maybe Melly jumped out of the car. Whatever they think their theory is going to be, make it as though the shots came from the outside. You heard David Howard at one point when Christopher Williams was on that stand saying, look, this is the way it happened. It couldn't have been other ways. David Howard kept saying, but couldn't it have been from the outside? So I definitely think they should put someone on.
All right, one final question from Corbin Britton. Was it really 9 not guilty and 3 guilty? Any truth? We don't know. That's what Melly's mom is saying. We are out of time. So everybody, thank you so much for joining us. Terry, thank you for being here. Afi as well. Linda's going to take it from here when we get back after this quick break. So stay with us. I'm Anjanette Levy, and you are watching Law and Crime.